Well, welcome to the latest Aspect webinar in this Aspect webinar series. My name's Sarah McNaughton. I am facilitating this session on data, IP and commercialization, taking a strategic view. And today's talk is going to look at the work of research institutions, academics and businesses, which often involves and increasingly involves collecting, analyzing and publishing third-party data. It's something that I certainly come across more and more as I'm doing commercialization support for different offices. And whether you're working with the big data sets from databases or whether you're working with tiny data sets from websites, from personalized data, anonymized data, or indeed publicly available data, there are laws that regulate the use of this data across the board and its use by third parties. Understanding those data regulations, even if it's just for research use, can be very, very complex and is increasingly so. So this strategic session really aims to outline the risks, the opportunities and the challenges that researchers and businesses can encounter when managing data. The session is going to start with a discussion to help provide academics and support professionals involved in research and commercialization activities with a bit of practical information to help in that third-party data use and to protect their own intellectual output. And just a really important reminder that, remember, this webinar itself does not constitute legal advice. And I'll be reminding you of that again at the end of the webinar. We have a really interesting group of 4 experts, and they each approach the issue of data from very different standpoints. I'm going to just briefly introduce them before I hand over to themselves to give themselves a little bit more of an introduction. So our team are Martin Hušević, I'm hoping I'm pronouncing that right, who is he's a lecturer in the area of intellectual property, digital rights and EU law at the LSE. We have Geraldine Wildman from the BGS, British Geological Survey. We have James Boyle, who is a senior associate with Taylor Vintners, and who leads the firm's privacy and data protection team. And we have Hugh Tebay, who is a partner with Taylor Vintners. So I'm going to go straight over to Martin, first up, to introduce himself with a little bit more, and then we'll move across to each of the other panelists.
Okay, hello everyone. Yeah, my name is Martin. I'm an assistant professor here at LSE. And as you can see from this sadly looking bookcase, I just recently joined. And I'm interested in all kinds of questions related to tech, law and IP law, which has intersected when it intersects with the tech. And yeah, I'm really excited to share some interesting experiences and stories that I had a chance to deal with in the last couple of years in this area.
Brilliant, thank you, Martin. Over to you, Geraldine.
Yep, good morning. Yes, so I'm Geraldine Wildman. I work for the British Geological Survey and have done for many, many more years than I believe, to be honest. My role is around making sure that the data that we have gets out there and gets used. I used to develop a number of data sets myself, and now I'm on the other side of the fence and I'm helping to distribute them, so I sort of understand the full spectrum of data use through to data delivery. And yeah, really looking forward to being here today and to sharing some of the experience that BGS have had with regards to getting our data out there, getting it commercialised and getting some impact. Thank you.
Thank you, Jerry. I'm looking forward to that as well. I remember working with BGS many, many, many years ago, so this is really interesting to me. James, over to you.
Thank you. Hi everyone, I'm James. I'm a technology lawyer at Taylor Vintners with a focus on privacy and data protection. My day-to-day work centres around helping our clients use data, whether that's for research, to better understand their customers, or understanding what the boundaries are when they're looking to buy or sell data. I'm really looking forward to the discussion and questions from the audience here. Not least because my personal view is that the data protection laws provide us with an ethical framework for research and innovation, rather than necessarily having a chilling effect on research and progress. In the few initial minutes I wanted to talk briefly about some hot topics. So it's hard to kind of get there without looking at digital health, consent, and the right to erasure. And so there's really tricky overlap between these concepts, and some recent guidance focuses on the interplay between GDPR and clinical trials. And this draws a distinction between collecting consent for a medical procedure, which of course you'd need to take a sample from someone, otherwise it would be assault, and consent to processing their data associated with their involvement in the clinical trial. And the upshot of this guidance is that we shouldn't necessarily leap to collecting consent. So I'm really looking forward to chatting about all of these things with you. Yeah, thank you.
Brilliant. I'm again specifically looking forward to that session because I work very much with the GDPR aspects of my own company. So I'm really looking forward to that. And Hugh, just for a final brief introduction before we go into the detail.
Thank you, Sarah. Hello, everyone. Yes, I'm a partner with the firm Taylor Ventures, and we're a firm that specialises in advising entrepreneurs and innovators from startups and university spin-outs to multinationals. And my particular area of specialism is intellectual property, and I spend most of my time advising businesses on developing their IP strategies and in particular how to manage and commercialize their valuable IP assets. So yes, looking forward to discussing some of the legal bits. I hope it's not too tedious on the legal side. It's a little bit dry, but I think the discussion afterwards will be very interesting as we get grounded in practicalities as well. Thank you.
Brilliant. Thank you very much. And Hugh, last one I threw to on the introductions, if you'd like to tell us a little bit more about what you do. We thought starting with the IP side and the basics of it would be the best way to go. About 5 minutes, if that's okay with you, and then
Certainly.
Moving to Jerry, Martin and James.
Thank you very much. Yes, I'm going to just spend a few minutes giving some background to the legal issues affecting the creation and use of data. And I'm going to be focusing on the interplay between IP rights, the limitation on the scope of those rights, and contract terms. I'm leaving the data protection side to James very happily. So he's the real expert in that field, so he'll be picking that up a little later on. So for any research project that involves the generation of data or the use of third-party data, early consideration should always be given to the IP and contractual landscape. A failure to consider your own and third-party rights can risk the success of your research project and can have serious consequences. For example, you might find that you're not entitled to use the results generated by your project in the way you require because you've not secured the appropriate rights to use the underlying third-party data. Or you may find you're contractually restricted on how you can use your data and materials generated in your project because of limitations imposed by a collaborator or a funder to your project. And on the other side of the coin, you might miss out on opportunities to commercialize the project results because you haven't structured your data sets in perhaps the most beneficial way, or you haven't imposed suitable contractual controls over who can access your data and how they're allowed to use it. As I'm sure a lot of you are aware, IP rights allow creators of intellectual assets to enjoy the benefits of their creative processes by giving the owners the right to take action against unauthorized use by others. And there are a number of different rights we need to have in mind when we're looking at this landscape that protect different types of creative work. So there's patents, which protect inventions, there's trademarks, which protect distinctive brands. And where we're talking about data and databases, we're particularly interested in copyright and database rights. So there are these layers of intellectual property rights we need to think of as well. So if we have a digital image library, for example, there may be copyright rights in the individual images included in that library, and there are also database rights, or there might well be database rights in the database itself. So we also need to be aware of these layers of intellectual property rights that may exist. I mentioned earlier limitations to the scope of intellectual property rights, and there are some exceptions that may allow you to access other people's protected works. And I'm talking in particular about the sort of fair dealing exceptions to the use of copyright materials and actions such as computational analysis of third-party data sets. But it's really important to remember that these limitations are limited in their scope. And so you need to be very, very careful if you're looking to rely on them. So if you're carrying out a TDM exercise, text and data, text mining and analysis project on somebody else's materials, you must still have accessed that data in a lawful way, and you could only use the results of your analysis for non-commercial purposes. And there's a lot of thought and discussion around what non-commercial means in different situations. So understanding these restrictions and their limitations is critical and shouldn't be relied on without great care. It's also important to appreciate that some bits of data and some collections of data don't benefit from IP protection at all. So, for example, a collection of numbers generated from an AI analysis of other people's materials, if it's not structured in a clever way, it may well not benefit from any copyright or database right protection at all. But the absence of IP rights is not the end of the story either. So you have contractual controls over how data can be accessed and used. And so these also need to be considered very carefully at the outset. Contractual terms can be used to increase the scope of your protection of your own data by restricting access and limiting the scope of use by other people of your data sets. And these controls, these contractual provisions, may be included in negotiated contracts, so collaboration agreements, for example, or licenses, or they might just be terms of website use. So you go and access a third-party website and you want to scrape some material from there. But most websites have these general terms of use applying to all users of the sites. And most of those terms expressly prohibit web scraping or other copying. And just finally on contractual restrictions, I'll just add that where there are a number of parties collaborating on a project, there are likely to be provisions in place setting out who owns what in terms of the results of the project and how each participant may use the data. So those all need to be considered as well. So all these issues all need to be considered early on in the project process, and they're not straightforward. But if you plan properly at the start of the project, you can help minimize the risks of breaching others' intellectual property rights and maximizing the value you can derive. Issues such as what isn't protected by IP rights, what constitutes non-commercial use, and differences in the laws and how they're applied in different territories make this a really complex area. So as you can imagine, I would say we always recommend involving your specialist advisors at an early stage so you get a clear picture of that legal landscape, and that can help you frame your project strategy. I'm really looking forward to our discussion in a minute, and that's more than enough to hear from me at this stage. So I look forward to chatting later, and I'll hand back to Sarah.
Brilliant. Thank you very much, Hugh. I think that sets this up really well. Always good to have the planning up front, I think. Moving on to someone who then engages with and uses data sets a lot. I'll move over to Jerry, and then again, about 5 minutes, tell us a bit more about what you do with BGS and the public database and maybe some of the issues that you come across.
Great, okay, thank you, Sarah. So, the British Geological Survey, just to give you a bit of background as to the organisation that I work for. So the British Geological Survey is an ERC institution. It sits within UK Research and Innovation. So we're a publicly funded body. Now the geology bit may or may not be of interest to you. It certainly is to me, but I think the fundamental principles to what we do probably are very relevant to this discussion. So as a publicly owned research body, we get around 50% of our income through direct funds via the UKRI route. The other 50% we have to go out and win. And I think that's quite an important thing to say up front, because commercialising our data is one of the ways in which we bring in the income. So as a public body, as a publicly funded research body, we have three main remits. The first as a public body is to make our data available, to make our public science data that we collect on behalf of the nation available to everyone. The second string to our bow, if you like, is as a research body, we do an awful lot of research with the data, and we consume other people's data, other people's information. We work with a wide variety of collaborators internationally and nationally. So we are a research body, and we do an awful lot of great peer-reviewed scientific research. And then the third element to what we do, as mentioned earlier, is trying to take some of that data and some of that research and to commercialise it. So if I can give you an example of one of the data sets that we commercialise at the moment, is we have a subsidence data set which we resell through to conveyancers and to insurance companies. So we've taken some of our research, we've taken some of the data that we have and hold for the nation, and we've added a significant level of value add on top of that to turn it into a commercial service. So I've talked there about the three elements of what we do as a public body, as a research body, and trying to commercialise. They're not three distinct elements to BGS. In fact, what they're closer to is three apexes or 3 points on a triangle. And quite a lot of the work we do doesn't actually sit at either of or any of the apexes. It sits somewhere within that triangle, and trying to figure out where that is, where the opportunities are, and where we should balance our portfolio, where our resources are, remains an ongoing, I would say, challenge. And it's the interesting part of the job as far as I'm concerned. But it definitely is a consideration that we have to make when we're deciding which projects to get involved with and who to collaborate with. And then finally, really, just a word, the other thing that is important to point out at this point is around impact. We do an awful lot of work, and the impact that it has ranges from impact on ourselves as an organisation, through to our data users, through to the general public. And understanding that broad range of impact, to say not just the impact, the direct impact BGS, but the downstream impact, is something that we're spending an awful lot of time and effort on right now. And obviously being able to use data in our research is a fundamental part of that impact. So I think that's all I'll say initially. And if I hand back to you, Sarah, and we can move on to the rest of the panel. Thank you.
Brilliant. Thank you very much, Jerry. I'm going to move on to Martin now. And if you can give us a little bit more about the academics point of view, very much, I think, around data collection, analysis and publication. But yeah, I'd be really fascinated by this. Thank you.
Thank you, Sarah. Okay, so I'd like to deliver my points through a story from which I try to draw some very quick lessons. So this story happened in 2015, which was before we had current copyright reform in Europe. So the laws have slightly changed in the meantime. But the story goes as follows. There was a social science researcher at a random university in the Netherlands who wanted to do some research about how humans relate to music. So she tried to study, she tried to scrape and observe a particular service, a musical service online, and looking at specific patterns in which music is popular and not. She tried to draw some interesting insights for her domain. Now, when she set up the project, she didn't really think hard about getting a permission of anyone or even investigating who owns the data. She simply wrote a bot and sent the bot to a particular service to essentially collect the information, and then that most of the analytics on its own. what happened, obviously, is that later on a problem arose, namely when she wanted to publish the paper, which was based on this data set, which turned out to have some really interesting insights, perhaps not so flattering to a particular service, or perhaps not so good for particular service and its business model. She decided that it would make sense to approach this service and tell them that she actually used the data. And at that point, service decided to say no and point out to the fact that that data collection was a violation of number of IP rights that they own into the data. So at that point, of course, is when this particular researcher comes to me, because she scrolls through the website of the university and finds out, oh, this guy does IP. So she comes to me and says, oh, Martin, I have this trouble. What shall I do? I need this paper for this research project where I might get 200,000 euros. And on top, it's important for my tenure file as well. And now I would need to pull it from the publication. So we sit down, and I told her, look, let's look at the terms of use, as you has mentioned. Let's look at the different rights. Of course, terms of use were very dismissive of research, and of course, she violated both copyright as well as so-called sui generis database right for a number of reasons. So now what? So I had to sort of tell her, like, look. When it comes to law, the situation is that they are correct. But then I told her, look, but the fact that the copyright law or sui generis database law is violated in this case doesn't necessarily mean that they would actually try to enforce it. Of course, you don't want this kind of situation to happen to you. So I'm not saying the fact what happens in a second is a takeaway that you should follow this. But So what happens is that I tell her, look, it's going to look bad if they try to stop this. Let's write a letter together. So we wrote a letter together saying, it might be, maybe, there are some other theories how we could interpret the scope of the right and some exceptions. But the main point is, you don't want me to go to media to actually say that you are trying to stop this research. It's ridiculous. It's not competing with you in any way. It's just trying to draw some insights for social science. So the company backed off, and the researcher got really happy, obviously, and became a friend. But it's a success story that doesn't have to repeat all the time, I can tell you, because some other companies might have very different incentives, and you might be encroaching upon the territory much more. So several takeaways from this. First of all, do your due diligence. So I think you already mentioned this. It's really important to avoid bad surprises. The point is not really, you can find out that there's some risk. And I would actually say that social scientists are pushing the boundary with their research tool of how the law should look like. So that's all right, but you should know the risks up front. So you shouldn't get yourself in a situation where you don't have any options and just have the downside. I think that's an important thing to keep in mind. Second, and I always emphasize it to my students, there are alternatives to data that you want to use. So sometimes there are publicly accessible, there are publicly funded data sets that are in public domain. Sometimes they're open source licensed data sets that might come with some conditions, but still might be useful. And in addition, sometimes you might actually use data subjects, maybe James will talk about this, to help you to collect the information through their data access or data portability rights. And those are all options how you can actually get similar data set and compose it in a lawful way. So there are alternatives, and think about it so you know the risks up front. Now, if you find out that the currently law doesn't support your mission, do not be upset immediately and do not abandon the project. I think sometimes it's really worth in thinking through the strategy, what to do, because the law can be just wrong. I mean, look, 2015, the law was very wrong for that particular researcher, and I think exceptions were really missing in copyright law. And there were some theories how we could defend the guy, but it takes a lot of work and expensive litigation. But maybe that's a mission of universities too. So last point, even if you find out that something is okay for you to do as a researcher, keep in mind that very often the laws that allow you that are limited to that scenario. In other words, this is what he already mentioned, a lot of exceptions that might allow you to do something without seeking permission are conditioned upon the fact that you do it for non-commercial purposes. So if you try to, you have an interesting insight and suddenly you want to immediately scale it into a business, well, hold on. There might be a very different analysis that you need to do for those purposes. And you would be surprised, but things like, who you do the entire research with, how do you store your data? Do you store your data at all? Is it just interim copies? What kind of security do you have? Do you care about the opt-outs? All of those things can matter big time in setting up your research project if you want to do some commercialization at some point. So I guess my main takeaway here is that do your due diligence up front, just to know the risks. And if there are risks, well, keep in mind law can be changed, and maybe that's part of the mission, but you need to find someone who can help you to change the law.
Brilliant. Thank you very much, Martin. And we will be coming back to you again after James, in that I know you're leaving at 11:45, so we do have a couple of questions for you. Over though now to James and GDPR, the issues that you need to be aware of. 5 to 7 minutes, if that's okay, James.
Sounds good, thank you. So I think I'm going to split the few minutes I have up into 3 broad questions and then round up with 2 slightly larger topics towards the end. So I think it's a sensible starting point for any research to look into whether or not the data you need is identifiable or not. And it sounds super basic, but this is perhaps the easiest way to triage the extent of your legal obligations under the GDPR. And so if you do need identifiable data for your research, then of course the data protection legislation and the GDPR will apply. But as Martin mentioned earlier, it's very much worth looking into what's the real value we're looking to extract from this research, and are we able to still get to that same endpoint without relying on data that is identifiable. Some of you may quite rightly be thinking, well, that's all well and good, but what actually is and isn't identifiable is a bit of an open question at the moment, and you'd be absolutely right. The broad test is essentially how likely is it that somebody could identify a single person based on the data that you hold. I'd be really interested to hear, as part of the Q&A, people's views on that and kind of whether anyone has been able to successfully move away from an identifiable data set to an anonymized one at the start of their research. So let's assume that the data you need for research has to be identifiable for you to carry out the research properly. So probably the second question to ask in my mind is, are we collaborating with anyone here? Or who else is involved? And the reason why this matters is because if we are exercising discretion or control over how identifiable data is being used with somebody else, then it's likely that we'll be a data controller. And just for those of you who aren't familiar with the terminology, if you're a data controller, then you're the one that's responsible for making sure that you comply with data protection law. And the reason why this matters is because it's a bit of a hot topic at the moment, because we've seen more and more cases coming out in Europe in particular, kind of confirming that it's very possible for more than one organization involved in research to be a data controller. And you can actually be joint data controllers with the other people that you're collaborating with in your research. And so one of the other things to sort out is to look at how involved are we with other people? Who's exercising these who's making these decisions? Because the closer you get to having multiple different organizations exercising discretion and control over the data, the more likely it is that there'll be more than one data controller. And to avoid this becoming a tangled web very quickly, one of the things that you're required to do when you have a relationship with another controller is to work out in advance, well, how are we going to work together if somebody writes in and says, I need to delete everything, or I want a copy of everything you've got about me within your research. So as Hugh mentioned, this is very much one of the things to try and triage up front. Thankfully, it isn't particularly difficult to do. It's just one thing that is very much worth doing at the outset. So the third point I wanted to talk about was, if you are a data controller, then probably one of the main things you have to do under data protection law is to choose, the technical term is which lawful basis you're going to be using. And you can think of these as effectively a menu or a shopping list set out in data protection law. And data protection law essentially says that if you handle identifiable data, then in order for that to be lawful, you have to be able to allocate your use of data to one of these lawful bases. So some of you have probably heard of these already. The obvious one is consent, but there are others. So if you have a contract with the individual, or if you have a legitimate interest to use the data, or one that's been particularly relevant for the COVID tracing app actually is where you can say that your use of that identifiable data is in the public interest. And that one is really, really critical for researchers. Now, so choosing your lawful basis is a really important thing to do, because which one you go for impacts what rights individuals have over the data that you hold. So generally, if you go down the consent route, people have very broad rights over it. But those rights are much more limited, for example, if you went down the public interest route instead. And so I hinted earlier in the introduction that leaping to consent in a digital health context isn't always the right choice. And I wanted to kind of give some more detail around that. So avoiding consent in a digital health context with data can initially feel super counterintuitive, but in many ways it also makes sense. And this is because data protection consent, which I'm at pains to make clear, is very, very different from the consent that has to be given for anybody to take a sample from your body, for example. So data protection consent has to be genuinely freely given, amongst other things. And it can be quite difficult to argue that that consent is genuinely freely given if somebody is participating in some form of clinical trial or in a digital health context when they're ill, and this could be a potentially life-saving experience. Potentially not relying on consent as well has a huge consequential impact around what you would need to do when you receive something like a request for erasure, or if consent is withdrawn. And again, if this has struck a chord with anyone, I'd be really interested to hear how you approach consent generally in your use of identifiable data in research. So on to the final 2 points. It's also worth mentioning, I think, that the GDPR does grant research a privileged status. So there are broad parallels here to fair use in the copyright legislation. And the general starting point is that identifiable data can only be used for the purpose it was originally collected for. And if you wanted to change the reason why you're using that data, you'd need to go back and get consent from the affected data subjects. But the GDPR grants a little bit more flexibility here, allowing the use of personal data for research, even if that wasn't the original purpose the data was collected for, without having to go back and collect consent from the affected data subjects. And whilst that does give us some very welcome flexibility, it's not a silver bullet here, because the other principles under data protection law very, very much continue to apply. And so the final thing I'll say with the view to how things set context here when we talk about the data protection legislation is that it's very easy to forget how odd data protection law is. We're very used to rules-based laws in this country, which require us to, for example, stick to preset speed limits, or they give us a fixed time period in which we can return something we bought online. But data protection law isn't like that. It's mostly principles-based. So on the one hand, this is helpful because it gives us flexibility around how we conduct research and what data we can use to do that. But on the other hand, it creates a vast amount of uncertainty because it makes it difficult to know what the right thing to do is. Thankfully, the answer here is there's usually more than one right answer when it comes to using identifiable data for research. And you won't go far wrong if you keep the foundational principles in mind when you're planning. And when I say the foundational principles, I mean things like being transparent about what you're doing, making sure you're only using the data that's necessary, and ensuring you're set up to facilitate individuals whose data it is exercising the rights and controls they have over it, which, as I mentioned earlier, can actually be fairly limited depending on how you set up the research. So I'll pass back over to Sarah now.
Brilliant, thank you very much. I think we've got 4 very different perspectives there on very complex subject, but actually one that is changing all the time, but also, as you say, with those firm principles that people can work within. We already have a lot of questions that have come in, so I will very shortly go straight to those questions, but I am aware, as I said, that Martin is leaving us at 11:45. And we did have sort of one question for you in particular, Martin, around the challenges and opportunities that you see within HEIs, within universities, research institutes, for data, for databases, for software, specifically around the entrepreneurship and innovation agenda that is becoming increasingly part of the national dialogue, I would say. So if you could tell us a little bit about that, what you see as those real challenges for researchers in these spaces. We've only got about 5 minutes, so over to you on that, if that's okay.
Okay, thank you. Well, I will just very quick. I think we had a very interesting debate about this also with your colleague the other day. I think the obvious challenge is that you need to improve sort of literacy of social scientists when it comes to this basic legal questions. And I think it seems that data protection law is actually even slightly better on this than IP. So I have a feeling that many people, at least through sort of regulatory approvals, are getting a little bit more a sense of data protection interests of potential data subjects that they might engage in when they do data research. And that has become really sort of engraved in the entire approval if you want to actually carry out some more sensitive research. But IP questions seem to be neglected so far, probably because there are not that many cases where it would probably, or famous cases where it would happen that stuff gets blocked. But I don't. I mean, in terms of research results being blocked because of the data they use. But I think as we're moving to the economy where you're observing how people live by essentially scraping the patterns of their behavior from the online services, you realize that you will engage with those questions much more. And someone's behavior can be someone's property interest, and that's something you want to clarify up front. Again, it's not like IP should be here something that stops the research, but it should help you to guide the research and its trajectory and a strategy so that you know where you have fewer risks, where you have more risks, and what you can do with them, how you can mitigate them, what kind of strategies you can deploy. And possibly for those people who have some more entrepreneurial streak, it also allows them to see whether today's decisions can influence and foreclose, future opportunities. So I think that's also interesting for those social scientists that might be interested in commercialization of some ideas or some solutions that they find in their research, that they want to know what kind of path dependencies they create by different choices that they make. So yeah, this kind of due diligence and thinking about this, I think would make a lot of sense for many social scientists. And as we work with data increasingly and data sources are becoming increasingly somehow entangled with someone's property interests, I think it is a very crucial skill to gain in the coming years.
Yes, I'd just like to add to that, if I may. Sorry, just to agree with you and just say that we have certainly seen, particularly during this period since lockdown, a real boom in entrepreneurial activity around using data in a very creative way. And I think data really is king, as the phrase goes. So the opportunities to look for some kind of commercial collaboration to gain value from your data sets is increasing dramatically.
Okay. And James, specifically around GDPR, essentially, if we're talking about web scraping and maybe web scraping behavioral traits, where does GDPR come in with that, in your experience?
So great question. And there are actually a couple of elements to unpick there. So the starting point with anything to do with web scraping is exactly how you're doing that to pick up on behavioral traits is super relevant. Because in brief, if you're doing that by saving things on users' devices, then you start to be caught by all of the cookies rules, which require consent to be collected, irrespective of whether the data is identifiable or not. But let's assume, for example, for now, that you're not caught by those rules. So as soon as you cross the barrier into being able to sensibly distinguish somebody from a group, or if you were collecting their IP address, for example, because an IP address is called out as a specific example of an identifier, then you should really be thinking about the GDPR probably applies here. There are some saving graces for research, and for those of you who like diving into the detail, I would encourage you to look at Article 14 of the GDPR. Which towards the bottom has a few elements there around how if communicating to people that you hold their data would involve a disproportionate effort or would be impossible, then you don't always have to do that. But again, don't take that as a silver bullet. It's very much on you to establish a balance here where you can show that it genuinely would be disproportionate to have to reach out to everybody. There are some really useful litmus tests here. And so when I was at the ICO's practitioners conference a couple of years ago, they said you can ask yourself two really common sense questions here if you're unsure about where you are. The first one is it creepy? And the second one is, am I being a git? And the answer, like if the answer to either of those is yes, then I would really encourage you to go into more detail and look at what you need to do. The ICO's website is a fantastic resource of free guidance there. You really won't go far wrong if you spend time there. But again, like I would also be inclined to circle back to foundational principles. If you are web scraping for behavioral traits, work out actually which of those behavioral traits are super valuable to us and which things could potentially qualify as identifiers and render the whole data set identifiable could we drop, to try and be more privacy friendly and perhaps end up with only a set of anonymized data and anonymized research. And if we can get to that point, then the data protection legislation falls away.
Sorry, Sarah, you're on mute, I think, still.
Thank you very much, Martin. He's leaving us now to teach a class, but really appreciated your presence and everything you said. Thank you.
Thank you. My pleasure. Bye-bye.
Bye-bye.
Sarah, could I just leap in on that last question again on to do with web scraping and leaving aside the data protection side of it again, just be careful if you are web scraping to make sure you're doing it in a way that doesn't infringe either contractual rights or anyone else's intellectual property rights. So again, make sure you have lawful access to the site you're scraping from. And if you want to use it for commercial purposes, just make sure you comply with any restrictions on how you can do that. There are exceptions to allow you to web scrape for non-commercial purposes, but you have to give an acknowledgement to where you source the data from, and also, as I say, you just have to make sure that you're lawfully accessing the database.
Brilliant. Thank you very much. Is there anything else on that question from any of the other panelists before we move on to the first question? Nope. Okay. Well, this one I think is pointed at Hugh.
Yes.
And this one comes from an attendee. What happens when a website has multiple layers of terms and conditions or no T's and C's on the website? Which terms are the ones you need to consider? And if they are absent, does this mean that there aren't any? Over to you.
That's another very good question, and yes, quite often you go onto a website and you have these different terms and conditions. You'll have the general website terms and conditions, you'll have the privacy policy, the cookie policy, then you'll go and register and there'll be another set of terms and conditions. You have to click on the accept button. So yes, you have to make sure that you're looking at the right set. Now, if generally speaking, if you're just looking at a website and taking data from there that's not behind any other kind of firewall or any kind of registration or subscription panel, then you'll be dealing with the general website terms. But if you've gone deeper and you register, there will normally be specific terms that apply to what you want to do through that portal. So you would normally consider those. Now, ideally, those terms will all fit together very neatly, and one would clearly take priority over the other. But we have to look at this on a case-by-case basis. But generally speaking, the further you dive in, the last set of terms and conditions tend to be the ones that apply. But it may be that two or three work together. And then there's the question of which terms, what if there are no terms and conditions there? It does happen. It does happen. There should always be some there. But sometimes you go into a website and there will be absolutely nothing there. And if there are no terms and conditions, then there are no contractual terms that you have to worry about, because those terms and conditions have to be clear and your attention has to be drawn to them in a reasonable way for you to be bound by them. And if there are none there, you're not bound by any website terms and conditions. But that doesn't mean there, just to make life even more complicated, there are still underlying intellectual property rights that you need to consider. So the fact there are no contractual terms that may govern your use, you still have to consider the underlying intellectual property rights. So you have to work out whether you're going to infringe copyright or whether you can bring yourself into one of the exceptions. I hope that answers the question.
Brilliant. Thank you very much. I'm actually going to move on now to some questions for Jerry. I've got a couple of questions that have come in around the data that BGS produces, commercializes. So the first one is actually what types of data does BGS have? Where do they come from? And I love this. Is it really horribly complex contractually? And how do you deal with it for public access and commercialization? So a few questions in there, and then follow up to that.
Great. Okay. I mean, BGS has been around since 1835, and we've been collecting data, information, fossils, rocks, everything since then. So we have a vast amount of data that we hold, and not all of it is owned by us. In fact, the majority of the data that we own is not owned by us. And if I give an example of some of our, we've got a collection of borehole logs that date back probably 100 years or so. And these logs have been, some of them are hand drawn, some of them more recent ones are donated digitally. At no point when we received that data from the organisations that sent it into us, did people perceive that one day we'd want to digitise all of this and put it on the website. So going back through all of this legacy information and trying to iron out any ongoing sharing rights or terms and conditions is impossible in many cases. So we have to take a slightly more pragmatic view to when we release data. So in the case of the boreholes, we put notifications out of our intentions to release this information, and then took a risk-based approach to releasing it with the takedown policy. With the information that we receive today, obviously we can be quite clear about when we ingest data, what terms and conditions we ingest that data on, and are quite clear about what we intend to do with it. Our preferred option is to release any information given to us under the Open Government Licence, because obviously that's quite an open, well, it's an incredibly open licence that allows people to do pretty much whatever they want with it as long as they acknowledge the source. Delivering data or reissuing data under an Open Government Licence is by far easier because it doesn't involve protracted negotiations around the costs, for example, royalty payments if a data set is jointly owned. As soon as you start talking about sharing commercial revenue, the conversations get far, far more complicated. So we try and keep it as open as possible. So that's the situation with regards to a lot of the information that's donated to us. We do hold some information ourselves and some of the data products that we have commercialised. And with those few data sets, we carve up whether they should be delivered under an open license, whether they should be delivered under a reseller arrangement, a commercial arrangement. And with all of our data, we allow people to innovate and research with it for free. So we have these very constrained routes through which we push our own data out through.
And do you have a sort of set of rules around whether you're going to do commercialization? Are there any kind of simplified systems that you have maybe in your framework?
No, I wouldn't say there was anything simple about it necessarily, but it goes back to the impact of releasing those data sets, where the impact will be. With the release of some of our borehole logs, the impact, the really big impact, is for the construction companies, because they can identify land that they can build on much more easier, and free up land for planning, and that then the impact then is much further down the line. So that's a very clear open data candidate, because the beneficiary of that data is ultimately the general public, the UK taxpayer. With our substance product that I talked about earlier in my intro, that we license through to insurance companies, the beneficiary to that data is predominantly the insurance company themselves. So the impact there is for a commercial organisation, so we tend to push that down to the commercial route. And of course, then, as I say, there's anything in between, sort of those two very open data sets and the more closed commercial ones.
Thank you very much. Is there anything anyone else would like to add? I don't think so on that particular question. That was quite specialist for Geraldine. One here that I'm not sure whether or not this is the right group to go to, but if you were going to the university, who would you go to with any university to help set up a strategy for access to data for research and commercialization? Who is the person that I guess you guys deal with when you're dealing with universities? Who is that person in control of those? Is that something that either James or Hugh can speak to maybe?
Yes, we tend to work with the innovation groups within the universities, who are the ones that those who are creating some interesting intellectual property and doing some interesting research and start considering how they might commercialize that. They'll go and speak to the innovation team, and there'll be discussion around whether there's going to be, is there an opportunity to license the technology, sorry, the intellectual property, and spin it out possibly into a separate new commercial entity. So normally there is an innovations team who will be very well placed to lead you through the process and discuss opportunities and the different possibilities that are open to you.
And from your point of view, working outside the university system, have you seen changes in the innovation teams over the past few years in terms of data, in terms of that kind of role? Has it changed?
Has it what, sorry?
Has it changed? Has it been taken from your experience?
Yes, I mean, there's a lot more activity that involves the use of large amounts of data, put it that way, and so there's a huge increase in activity generally. So yes, that's what I'd say. I mean, that there's a lot of research that has made use of either data generated within the HEI or from third-party sources. So the issues we're discussing today are certainly very much on the up.
And libraries, if you're a researcher, would that be a good place to go to? Jerry, do you maybe have some thoughts on that or anything?
I think I'm not sure how much I can contribute to this, but yeah, I think libraries tend to be the first stop, the first port of call. I mean, when we BGS deal with universities, like you were saying, it tends to be with the innovation teams and with the legal teams. But yeah, I think libraries are sort of seen as, certainly for all sort of copyright issues, seems to be the first point of view. The first port of call. Yeah.
Brilliant, thank you. Okay, I'm gonna a quick change of subject, and one that has come up a lot in the past few years from my point of view and often from my colleagues. So this one has come in around business cards, one of my favorite subjects around GDPR. So let's say you have a database of business cards, or you've done analysis of businesses in a sector, which as a consultant, I find myself doing quite a lot, and you have a database. And you've been given the business cards by the individual. What can you use this for? What can we use this information for? James, I think that one speaks to you immediately.
If you'd rather answer that one, Sarah, that's absolutely fine by me. I can go back on mute.
No, definitely this one is over to you from a GDPR point of view.
So good question. I think I'd be inclined to leap back to the foundational concepts here. So when we have a business card, or if we've collected somebody's contact information, because we've seen from their public profile on the website, for example, if we decided to collect that information, then we will be a data controller of that, almost certainly. So the next step then is to identify what lawful basis we're going to rely on to handle that information. And odds are we won't have collected consent from the individual. I would argue it's probably not in your interest to do that anyway, but that's a separate question. The one that tends to be most relevant when we talk about business cards in terms of the lawful bases is that it's in your legitimate interests to hold that information. So then there's a few kind of back-end compliance things to do when you're relying on legitimate interests. And this is really because it's very, very convenient that anyone can say, having this data happens to be in my legitimate interest, so thank you very much, I'm legally compliant. So in response to that being so flexible, there is now an expectation from the supervisory authority, which is the ICO in the UK, that when you're using legitimate interests, you'll complete something called a legitimate interest assessment. It's basically a super short form risk assessment that is designed to take you through what you're doing with data, why you think your use of data for those reasons is lawful. And the critical point here is, by the end of the assessment, you need to be able to show that on balance, what you're doing doesn't unfairly impact on the individual's privacy rights. And so one of the ways that you can show that you're not impacting on their privacy rights is to make sure you're telling people that you have their data and what you're doing with it. But this can often be really, really tricky if you're scraping contact information from websites. So where some of our clients end up as a middle ground is they will make public statements on their website designed to explain to people, like, this is how we collect data, this is what we do with it, and here are the rights and controls that you have over it. The thinking there being, yes, ideally we would tell everybody that we've collected it. We're not in a position to do that. So what is the next best thing? But the other thing that I would really encourage you to think about is, like, when we're just talking about business card data, the risk is much lower. But as soon as we start throwing into territory thinking, oh, it would be quite good to also record when they change jobs or any social media posts they make about their preferences, you can then start to look at this from the perspective of the individuals whose data you're collecting and ask the question, if they knew I was doing this, would they object to it? And if the answer to that question is yes, there is more work to do. But in the example given around holding business cards, the data protection legislation is reasonably practical and sensible. And as long as you're doing something that isn't disproportionate and doesn't unfairly impact on the privacy rights, you're broadly fine to do that.
Brilliant, thank you very much. Yeah, it's that am I being a creep question again.
Exactly. Yeah.
Very good way of looking at it, depending on your definition of creep, of course. Moving on to a question that I think really does look at the framework side of these things. I think, getting my head around the question, so I'm just going to read this one out. When assessing the risks of future legal action, should one take into consideration what the original purpose of the data protection law was when it was enacted? So that one is one to get your head around. James, you are actually nodding, which is very promising, which tends to suggest you may have something to answer on that question.
Yep, so another good question. I would say, like, yes, the original purpose that information was collected for is generally always going to be key when we're looking at data protection compliance. What I would say in terms of the risk of the law changing is that for now, I would say the risk of that happening is relatively low. Data protection law tends to change once every 20 years, and it changed recently in 2018. Although I know we do have some murmurings from the UK around the GDPR might be given the boot related to Brexit. But I think particularly in the kind of context that we're talking about here on the webinar, so research, use of data that has kind of a thread of social good or some kind of broader ethical societal contribution, I would say the risk here is particularly low. The reason why I say that with a degree of confidence is because if we look at what sectors were really put under pressure when the GDPR came in, and those are mass email marketers. So I'm sure you'll have remembered those, please click here or you won't get any more emails from us, and online behavior advertising. So those are really the industries that were put under huge pressure because when the GDPR came in, it did bring in some changes that completely put their business models at risk. But for the kind of topics that we're talking about here, it seems very unlikely to me that we would have to make substantial changes. What it would be worth keeping an eye on, I would say, almost more so than what data protection legislation is on the horizon for people in this sector, is keep an eye on what the European Data Protection Board are doing. So they are a group of supervisory authorities right the way across Europe that release guidance designed to help researchers understand how data is being used, and that the guidance is aimed at a whole bunch of people as well. But yeah, I would encourage you to kind of stay on top of that, because that's where at the moment I'm seeing the highest degree of change that's going to be relevant here. So one thing that I suspect will be coming in the near future, parking Privacy Shield for a moment, is the extent to which those research exemptions I mentioned earlier can be applied when that research is being used for a commercial purpose rather than for a non-commercial purpose. So I'd probably steer you in that direction rather than stargazing into what laws are on the horizon there.
Okay, thank you very much. That's it's quite a big one to think about. We have a lot of questions still coming in on privacy and data, so I will come back to those, but I've got one that's come in for Jerry, specifically around what do you see as the main problems that might be associated with the BGS data sets, research, the impact, and the commercialization agenda itself. So, minor in that one.
I think when we were talking about this the other week, I think one of the challenges that we have going forward is we're increasingly collaborating, and we're increasingly collaborating with non-BGS, with non-research organisations as much as research organisations. So one of the key challenges that we have at the moment is ironing out who is it that we want to collaborate with, what data can they bring to the table, what's the ongoing rights associated with any data that we collect and we share with them. So I certainly feel it's the big challenge there is around who we choose to engage with, and how we share the information and the data. And of course, the key to that is having very honest, upfront conversations right at the very start of the opportunity. And I think as well, the other challenge would be around focusing on what your institution wants or what your university wants rather than what you want personally as well. As researchers are fantastic free thinkers, but quite often, again, and speaking from BGS perspective, we find that maybe they've got a little bit too carried away with the research and carried away with their own science and sort of forgotten the remit of what the organisation, the institution wants to do with their information, their data. So certainly checking back in with the organisation to make sure that what you're proposing to do is aligns to what they want is a very important point as well. So I think that possibly answers the question. I'm not sure if I've left anything untouched.
I think just picking up on that, talking about collaboration agreements and collaborations, that we're seeing an increasing number of those right across the board. And one of our roles at the beginning is to play devil's advocate and start. We go straight to the end of the collaboration. That's one of the first questions we will discuss, is when we get to the end of this collaboration, everyone's very excited at the beginning, and everyone's clear what they want to contribute to the collaboration and what the main goal of the collaboration is. But let's look towards the end of it, what happens if it all breaks down for some reason, and dealing with who can do what with all the intellectual property and all the data that's been created is something that quite often gets left and not really resolved at the outset, and then it causes a big mess at the end of the project. So we always liken it a bit to talking to a newlywed couple and asking them to think about what happens when they get divorced. So it often puts a bit of a dampener on the early discussions, but it's really important to think that through, because it saves a lot of trouble later on.
Yeah, I think hopefully it's what happens when we actually get married, and
yes, exactly.
as opposed to go our separate ways, hopefully.
Yeah, I think it's addressing that elephant in the room. It's that very honest conversation you need to have at the very, very start, which is really, really important. I think quite often people tend to keep their cards quite close to their chest, which doesn't help us when we get further down the line. But yeah, so it's being honest to start with.
And also through the life of the project, people's perspectives change and their objectives change as well. So if you haven't sorted it out at the beginning, it can be very uncomfortable later on.
And in those circumstances, it's also so helpful to check in, therefore, as you go, and as a reminder of this.
Absolutely.
What you initially intended.
Absolutely, and there's always the opportunity to change the framework as well. So as the project evolves and adapts, you can change the contractual terms, but it's being on top of that at all stages.
So thank you for that one. I think there's another question here that's come from Matt Jones, which is associated with that one. So do people get to set their own terms and conditions freely? Are there any limits on what T's and C's someone can create for the use of their data? I think that probably goes to you data guys and law guys.
Well, if I can leap in very quickly, I'll just say yes and no, typical lawyer's answer. Yes, you are free to set your own terms and conditions up to a point, because the law does step in sometimes and say that restriction you've placed on your terms and conditions is not enforceable. So, for example, you can't stop somebody who has a fair dealing exemption for using your copyright material, and provided they fall within that, you can't stop them contractually from doing that. But now I'll just hand over to the others.
Yeah, I'm quite happy to chip in on this as well. So because it's something that we are giving an awful lot of attention to, is around making our data more interoperable and making our solutions. So if we think just from a technical point of view, we've spent an awful lot of effort with what was linked data, and now trying to make the data sets embed with each other, interoperate, or be interoperable across a variety of different organisations. What has been given less attention is the terms and conditions that go with that data. So something BGS are looking at is trying to harmonise our terms across as many different organisations as possible. So when it does come to work with interoperable data, the license conditions are interoperable as well. So on that, I would say if you can, stick to something like Creative Commons or some sort of terms and conditions that already exist, because it makes the onward use of that so much more straightforward.
Yeah, and that's something that hopefully everybody involved in this space would understand.
Yeah.
Great. If there's nothing else on that one, I have a question here, which is keen to get a steer on how to interpret the ruling on Privacy Shield from a point of view of a UK-based company. Who would like to take that?
Happy to.
There you go.
So I'll give some background in case anybody watching isn't familiar with the decision. There is a set of rules under data protection law that says, effectively, if you're based in the UK or the EU and you are transferring data to a supplier in the US, then you have to make sure that the US recipient of the data is committing to protect that data to effectively the same standard as if it was in the UK and the EU. And so one of the most common, if not the most common way of protecting these transfers to the US was to use a supplier in the US that had said, yeah, we certify under Privacy Shield. And it was a bit of a mic drop moment a few months ago because the European Court invalidated Privacy Shield as a mechanism of transferring data to the US with no grace period whatsoever. And this has split opinion across different EU territories around what they expect people to do when transferring data to the US. So Germany and the Netherlands, for example, are taking a relatively hard stance and saying you have to stop sending data to the US. And the reason why this mechanism was invalidated is essentially because of privacy concerns associated with US security agencies having access to data while it was both stored in the US, but also when it was being transferred to the US because of the visibility the US has over the undersea data cables. So that's the background. What does it mean for a UK company? Well, I would say that the UK's approach for now is please wait while we release updated guidance, is essentially what the ICO has said. But as with most things here, there is a legal answer and a slightly more practical one. So the black and white legal answer is now that transfers that were using Privacy Shield are non-compliant, so you need to look at alternatives. The obvious alternative here is to use something called the model clauses or the standard contractual clauses, which are a set of template clauses. They're freely available on the European Commission's website. Unfortunately, it's not quite that simple because in the same court decision, the court said just using these standard contractual clauses doesn't necessarily mean that the concerns we had over Privacy Shield have been dealt with. So the upshot is you can still use the model clauses or the standard contractual clauses, but you should be taking additional steps to reduce the likelihood of US security agencies having access to data when it's in transit and at rest. And we're waiting on more guidance from that body, the European Data Protection Board, on exactly what they consider to be appropriate additional measures to secure it. The main one that our clients have been talking about is making sure the data is encrypted in transit and at rest. But I'm sure, like, depending on how your data is flowing, what data it is, there may well be other techniques you can use. But yeah, the upshot is legally it's technically non-compliant to use Privacy Shield, and we should now be using an alternative with these additional measures in. From a practical perspective, the ICO for now is taking quite a relaxed approach because thankfully they're quite context sensitive and they know that this has created quite a big problem overnight. You may also take some comfort from the fact that a very similar thing happened back in 2015 with Privacy Shield's predecessor, which was called Safe Harbor. Again, non-compliant overnight because it was invalidated, but the regulators weren't enforcing this particularly in the immediate aftermath. So what some of our clients are doing as a middle ground is they're thinking, okay, like what are our critical data flows going to the US? And then they're reaching out to their suppliers to say, we assume you're aware of this decision. What are you doing about it? In cases where you are a customer in the UK going to a US supplier, I'd encourage you to adopt that approach. Like, start getting in touch with your suppliers, or at the very least triage what your critical data flows are that are affected by this decision.
Thank you very much indeed. I've got just, I think, I just got one sort of follow-up on that one before we sort of move to maybe some final questions, which was the Privacy Shield question. What about for a UK company using Microsoft Teams?
So, great question. Microsoft, in response to the decision, issued a statement on their website to say, we're very aware of it, and we already have integrated these standard contractual clauses into our DPA. So the larger suppliers that you work with, you may well find that they've already dealt with the issue for you. The main problem from a UK compliance perspective is likely to be with the smaller suppliers that were self-certifying under Privacy Shields and either aren't aware of the decision or aren't doing anything to put it right. But yeah, Microsoft is quite a good example, because certainly from what I've read on the website already, it looks like they've already dealt with it and they've taken the pain away from their customers.
Thank you very much. I've just got one more question that might be particularly of interest to university researchers around cloud services. Do cloud services complicate the whole strategy and the issue with databases, or how do they do so if they do? Not sure who to point that one to. Hugh, maybe?
Yes, well, I guess that the question here will largely come down. I mean, the same issues always apply. So it's always, when you're using a cloud service provider, either to store your own data or because you want to access some cloud-based system, there will be terms and conditions that govern your relationship with that cloud service provider. So, and the fun thing about cloud service provider terms and conditions is they're normally extremely lengthy and appear in tiny type as well. So there is and they're normally non-negotiable as well. So you're dealing with a standard set of terms and conditions that will be very lengthy and very detailed and quite impenetrable at times. So you have to just be very careful again about what restrictions are placed on you and what rights the cloud service provider has in relation to your data. Now, most of the larger and more professional ones, even though their terms and conditions are lengthy and detailed, they tend to be reasonably fair sometimes. Others aren't, and so you need to be very, very careful. And where you're storing your own data on a cloud-based service, it's making sure that you're not giving away too many rights. And similarly, if you want to access the cloud-based service, it's just being clear on what restrictions are imposed on you as regards what you can do with accessing and using the data you find there. But again, we have to think of this backdrop of intellectual property rights and the statutory exemptions from terms and conditions that may mean some of those stated terms and conditions are unenforceable. So it's a complex area, but you have to just read those terms and conditions and then consider what they say in light of what you want to do. But in effect, they're the same terms and conditions. Yeah, James.
You obviously caught that I unmuted myself.
I did. I saw that. Because you looking expectant. So.
I guess the other thing that I would add is if you're trusting a cloud service provider with identifiable data that you're the controller of, then you should be putting pressure on them to understand, like, are they trustworthy? And these, security questions are the obvious ones, but cloud providers differ hugely in terms of how they will mine and analyze the data that you trust them with. So some will quite openly say, yeah, if you store something on the platform, we're going to crawl all over it and use that to work out our own market trends that we can then sell onto our data partners. So the question there is, are you comfortable with that? Like, what kind of cloud service provider are you looking for from more of a due diligence perspective? The other thing to keep in mind is where they're based geographically will be relevant, particularly now after the Privacy Shield decision, and how are they protecting it. Right. And also keep in mind that I know I've been kind of saying that this is all principles based and there's no black and white answer with data protection law, but when you use a cloud-based provider to store identifiable data, this is one of the black and white areas. There needs to be a written contract in place between you that has a whole bunch of things in there around how they're going to protect the data. That checklist is available for free on the ICA's website. It's well worth a quick skim if you're about to contract with somebody that you're trusting with personal data.
Thank you very much. I have to admit, the ICO website was a lifesaver to me a few years ago for fairly obvious reasons. I think we're actually going to wrap up now. We have had a ton of questions, and I just want to thank you all for that. Just want to sort of finish with one sort of final question to each of you. If you could just come up with, obviously totally anonymously, one particular no-no howler that you've come across when you've been supporting the commercialization of IP and data. So just come up with something that you would never, never, never advise anybody to do, if that's okay to each of you. If there's anything that sticks in your mind that gives you nightmares, that makes you wake up in the morning slightly concerned, who would like to go first before we say goodbye?
Yeah, so I'll go. So don't as a researcher, don't suddenly agree to something because you're too scared to say no. And we see it a lot, and you know, something may be a great idea, somebody might have helped you out massively and they're asking you now for a favor, but just stop and consider it, and just have a think about whether it's the right thing to do. The knee-jerk reactions quite often tend to be the wrong ones, so just stop and think and sleep on it and speak to someone before signing ourselves up to something that we can't then get back out of. Yeah, that would be mine. Brilliant.
Yes, I think of a few here, but I think the main one, and it's very basic, and I'm always astonished by how many times I still see this happen. It's don't just assume because something's on a website somewhere that you can access that you can just use the materials on there. You know, so people will take photographs that appear, you know, they just access from a Google search and use that on their website, or they'll just take some documents that are freely available on the website and just use those without stopping and thinking that actually I'm not allowed to do this. You might be allowed to do it, but more often than not, you're not. The other thing I just briefly mentioned is that there is a myth out there that if you just change something a little bit, you're not infringing anyone's rights. So if you take a design or a diagram or some text, and I just change it a little bit, it'll be fine. Because believe me, more often than not, it's not. So yeah, just take great care.
Brilliant, thank you for those things that I've never done. Just very quickly, over to you, James, before we close.
I would say when you're using identifiable data in your research, think really carefully about that shopping menu of options. So which lawful basis are you going to use? And don't assume consent is always the right one. For sure, sometimes you will have to get consent, or you should do. But I would say that it's almost more unethical to leap to consent, and then when somebody tries to exercise the rights that they have because you used consent, you then turn around and say no. That strikes me as inherently unfair. So spend some time thinking about which one is appropriate, and there's a whole bunch of questionnaires and like checklists you can use again on the ICA's website. Sounds like I'm on commission, that can help you work out which one of those is the right one.
Brilliant. Well, thank you all, and thank you to Martin as well, who's no longer here. This, for me, certainly has been incredibly interesting, and I think for our participants as well. I've certainly seen an awful lot of questions come through, and what an amazing brains trust. I'd like to just remind people that this has been recording, so it will be made available later after this seminar, this webinar rather. That's me, I'm just old school. Don't forget the survey. That will be sent round by Adam later after this. And do remember there's quite a few more sessions in the Aspect annual event webinar series to come, all of incredibly interesting and different topics. And don't forget, nothing that you've heard today has been legal advice. It does not constitute legal advice. And that's a very, very important point, as all lawyers will tell you, sorry, when they're doing webinars. It's been a pleasure. Thank you very much. I think I will now sign off and take care, everybody. Bye-bye.